indicated that they did not intend to object to that. So I'm just going to grant the motion. I don't think we need to argue it unless Ms. Whitman, you think any different. And then we'll just go through a plea like normal after that.
Sounds good to me, Judge.
All right. Anything else we need to talk about before I call the case?
Not from the defense.
All right. Let's be on the record in case number 2019-CR983, captioned State of Kansas versus Fransisco Hernandez. Would the parties announce their appearances, please?
Karen Whitman for the state.
Garrett Solomon on behalf of Mr. Hernandez, who appears in person and in custody.
All right. We are here for two reasons. We are here for a motion to withdraw plea and a plea hearing. We had a prior plea in this case. At sentencing, the parties realized that the agreement made was not really reflective of the intent of the parties. Therefore, at that hearing, defense made a motion, an oral motion to withdraw plea. The state indicated that they would not object. I checked in with the parties again before going on the record today, and my understanding is that is still the intent. Therefore, unless someone feels the need to argue, I just plan on granting this motion at this time.
That is correct, Judge.
Thank you. All right. So I will show that for good cause shown, the defendant's motion to withdraw plea is hereby granted. With that, we will take up a new plea. I've received a plea petition before coming on the record today. Mr. Hernandez, unfortunately, instead of just being able to say, do you want to withdraw the old plea and do the new plea, we have to go through the whole format today, okay? I'll try and make it shorter since we just did this a few weeks ago, but we do need to touch certain legal bases. To do that, I need to have you sworn in, so if you would raise your right hand, my court reporter will swear you in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Mr. Hernandez. Go ahead and put your hand down. All right. So the plea petition seems to indicate that you completed your GED and that you read and write in the English language proficiently. Is that correct?
Yes, sir.
All right. As you sit here today, are you under the influence of any alcohol, drugs, or prescription medicine that might cloud your mind, keep you from understanding what you're doing?
No, sir.
Feel like your mind's clear today?
Yes, sir.
All right. You are still aware of the original charges in this case, is that correct?
Yes, sir.
All right. And you know that you don't have to change your plea from one of not guilty to guilty. If you decided to maintain your not guilty plea, you would have an absolute right to a jury trial. Do you understand that?
Yes, sir.
All right. At that jury trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You would not have to prove anything yourself. Mr. Solomon would help you throughout that trial. He would be able to cross-examine and confront all of the state's witnesses, challenge their evidence. If you wanted him to call witnesses, he could do that. And if they didn't want to come to court, he could use subpoena power to make them come to court. At that trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to take the stand, the state couldn't use that against you. In other words, they couldn't argue that you must be guilty because you didn't tell the jury your side. Do you understand all of those rights?
Yes, sir.
All right. Now, if we went through that whole trial and at the end of that you were convicted, you would have a right to appeal that conviction to the appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. You understand that?
Yes, sir.
All right. And once again, if I take this plea this morning, there's not going to be any kind of trial in this case at all, and you're going to give up all of those rights that I just talked about. You understand that?
Yes, sir.
All right. I'm going to call up now on the screen the plea petition that was presented to me. Can you see that?
Yes, sir.
All right. I'll go up to the top so you can see the caption. and then back down to the signature page. Is that the document that Mr. Solomon went over with you?
Yes, sir.
You feel like you understood everything in it?
Yes, sir.
The plea agreement states the following, that you're pleading no contest today. I think I said guilty earlier, but it's actually a no contest plea to the original complaint that was filed back in 2019. To count one of that complaint, involuntary manslaughter while under the influence of a substance. That's a level 4 person felony. You're going to agree to serve 34 months on count 1. You're going to agree to pay restitution, the minimum fine of $750 for a DUI, and the KBI fee of $400. You're going to get credit for all the time that you've served. You understand the court's not bound by these terms and may accept or reject the agreement and give you any sentence that the law allows. The court may impose any sentence within the statutory limits, grant or deny probation independently of the agreement. Is that your understanding of the plea agreement, Mr. Hernandez?
Yes, sir.
Anybody promised you anything else to get you plead guilty today? Or I'm sorry, no contest today?
No, sir.
Anyone placed any force or threats against you to make you plead no contest?
No, sir.
What I have to do right now is advise you of what the maximum that anybody could get for this crime is, okay? That would be assuming you have the very worst possible criminal history. A person could be sentenced to up to 172 months imprisonment, a fine of $100,000, I believe, on a level 4, and post-release of 36 months. Do you understand those are the maximum sentences in this case?
Yes, sir.
All right. Do you have any questions for me about anything we've gone over today?
No, sir.
Knowing all these things, is it still your intent to plead no contest?
Yes, sir.
All right. Mr. Solomon, do you know any legal reason why your client should not enter into this plea?
No, Your Honor.
All right. Therefore, I will ask you, Mr. Hernandez, as to count 1 of the original information, charging you with involuntary manslaughter, DUI, which is a severity level 4 person felony. How do you plead? Guilty, not guilty, or no contest?
No contest.
All right. I'm going to ask the state to tell me what they think they should put, if they had to put on a trial, what they believe the evidence would be. I want you to listen closely, because at the end, I'm not going to ask you if you agree or disagree with that evidence, just if you understand that that's what they believe they could put on. Okay?
Okay.
Ms. Whitman.
On August 22nd of 2019 at approximately 9:30 in the evening, a crash occurred in the area of I-70 and North 110th Street in Wyandotte County, Kansas. The defendant, Fransisco Hernandez, was identified as the driver of a white 2013 Chevy Malibu that caused the crash. Hernandez also would identify himself as the driver of the Malibu. It had struck the back end of a 2002 Ford van that was traveling down the middle of the road. The other vehicle, the Ford, the driver was identified as Douglas Walker. He was dead on the scene. While Mr. Hernandez was being attended by fire and EMS, they could detect, along with the troopers, a very strong odor of alcoholic beverage coming from him. His eyes were very bloodshot, watery, and glazed. His speech was slurred. He was transported to the University of Kansas Medical Center to receive medical attention. He was read the advisories and asked to take a blood test. He refused. A search warrant was issued and blood was drawn. That blood was submitted to the KBI. They analyzed it, and it was determined his blood alcohol level within 3 hours of the crash was 0.17. All these events occurred in Wyandotte County, Kansas.
All right, Mr. Hernandez, you heard what the prosecutor had to say.
Yes. Yes, sir.
All right. And you understand that that's what they believe they could put on for evidence if there was a trial in this case?
Yes, sir.
All right. I will find that the defendant has freely, voluntarily, and intelligently changed his plea from one of not guilty to no contest. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and based on their proffer, I will in fact find that Mr. Hernandez is guilty of count 1, involuntary manslaughter, DUI, a severity level 4 person felony. Any other charges are hereby dismissed. I'm going to order a new pre-sentence investigation and continue this for sentencing, pending receipt of that PSI. I've been in contact with the PSI writer. It seems to me that it should be very easy for them to just simply amend the charge, get the presumptive sentence in the right box and get it back to us. So I took the liberty of emailing the parties and my assistant to get a quick date. She tells me she could do this on February 26th at 9 a.m.
Unfortunately, Judge, I'm in Jackson County that morning for a pretrial conference.
All right.
And Fridays are really bad for me, Judge.
Okay. All right, here's what I'm going to do. First of all, I think we can get it done faster than that. And I'm going to let Miss St. James know that that is not available, or that the parties aren't available on that date. Remind me, the defendant, I'm trying to remember what our sentencing was. We think that he's going to be serving a period of time, right? He's not being released.
Correct. What we
Okay,
need.
so there's not that big a rush to get to sentencing. Does he have any kind of holds on him other than
Judge.
this?
Yes, Judge. He's got a felony hold out of Harvey County, which he would like to take care of through disposition of detainer. So, the quicker we can get it done, and he might be able to get that one resolved as well.
All right. So I'm not going to give you a date today. I'm just going to email both my assistant and the attorneys again, ask for something sooner than that, and let you guys kind of come to an agreement on that with my assistant, and then we'll get it all set up. Okay?
Yes, Judge.
All right. Mr. Hernandez, I think I did this last time when we did a plea, but I need to do it again. As a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. You understand that?
Yes, sir.
Okay. All right. Anything else for our record today?
None from
No,
the
I know of nothing, Judge.
All right. We are adjourned. Thank you, everyone. Once again, Rose, thank you very much. We'll see you at 1.
Thank you, Judge. I appreciate the time.
You bet.
Yes, Your Honor, thank you.